We're very happy to have a Norton Rose panel here with us today to discuss a review of the 2021-2022 judgments. And I myself am very excited to see what has been trending and what has been happening in the last year. So without further ado from me, over to the team from Norton Rose.
Hi, it's Michael Cronus. I'm a consultant at Norton Rose Fulbright. I send Donald Dinny's apologies. He unfortunately couldn't be present today. We've got quite a full program, so I implore to everyone to keep to the time limits, because otherwise we just shan't finish. I'll ask everyone just to introduce themselves when they start their talk. It's a review of some of the 2021 and 2022 insurance judgments, and I shall kick off with Discovery Insure Limited versus Masindi. This is quite an interesting decision and perhaps was not to be expected. This is a case where there was a valid claim for damage to buildings and contents, which was paid out. And then there was a further claim for emergency accommodation, which was also paid out. The policy had a fraudulent devices clause, as you can see, and because of that, the insurer declined and rejected both claims. Now, the court considered a previous case of Lembecker, where there had been a genuine claim and then a subsequent fraudulent claim, and it said because of the fraudulent devices clause, it would reject both claims, including the one original valid claim. The court in this instance, which was the High Court in Pretoria, followed that case and said, well, in the present case, there was a valid payment in respect of the buildings and contents, and then in respect of the accommodation, that was fraudulent. The valid portion was approximately 972,000 Rand. The claim for accommodation was 675,000 Rand, and it had not been used. The court said that if it were to reject both claims, that would be a penalty in respect of the valid payment. And it said it was not prepared to do this, and that if it were to do this, there would be, you'd have to consider the Conventional Penalties Act and all of that. And so it decided the valid portion of the claim, which had been paid, had accrued, and therefore they would uphold that portion of the claim. There had been a previous decision in Harkison and New National Assurance, where in the one claim there was a fraudulent aspect which had been completely rejected due to the fraud. In this case, it's different because the court is saying, first of all, there is a genuine portion which had been paid. So one must now be very careful when one rejects a claim that is partially fraudulent and partially genuine, and one needs to look at that very carefully. The second case is King Price. This was decided in the Gauteng division, but finally decided by the SCA. The question here is that one needs to look at what the promises are, and you will note that the word you is used often. It's you or anyone on your behalf. What happened here is that there was a claim, and it related to a motor vehicle being driven by an employee. The manager of the company was not sure what happened, so he suggested that the driver be interviewed and the driver gave a false and fraudulent statement, and the claim was then rejected on this basis of the fraudulent devices clause. The court examined whether it was the insured who had made the fraudulent claim and came to the conclusion that it was merely a fraudulent statement by a driver. The driver did not represent the company. The fraudulent statement was therefore not made by the you, which is the company. It was made only in a statement, and the statement wasn't meant to be from the company. It was merely from a driver who in fact did not represent the company, so the claim was upheld. The final case is that of Mochane versus Valuable Insurance MyWay. In this case, an insured had an accident and he replaced his vehicle. He then approached his normal insurer, who said they would not insure him because of the loss ratio. The whole question of loss ratio is the insurer's decision as to how much loss they are prepared to take, and has nothing to do with the risk of that particular driver. He then approaches MyWay and insures the vehicle. These questions are asked, and he then answers them truthfully. The main question is, have you been refused renewal of insurance? And the true answer to that is no. The question as to whether you had ever been refused insurance was not asked. However, when the insurer found out that, first of all, he had been refused insurance, they said that that was a material non-disclosure, and it was further a non-disclosure. The court looked at the questions that had been asked and came to the conclusion that he had answered them truthfully, and he'd not been asked if he ever was refused insurance. And secondly, it was not material because the loss ratio related to the insurer and not the insured, and the insured's risk profile. So once again, one will see the courts are leaning very much towards the insured, but note that I think this is a correct decision. And when you ask questions, you must make sure that you ask all the questions. If you leave one out, the courts aren't going to come to the assistance of the insurer. Thank you. Will you see it?
Hi, everyone. Thank you, Michael. So I'll be briefly touching on prescription in two very interesting matters. Although the through line is prescription, a sort of an underlying lesson here is to never get into business with your brother-in-law. I'll start with the first case. So Pretorius versus Bedwell is a case in which the plaintiff had approached his brother-in-law concerning home improvements that he wanted to effect to his guest house. And it was agreed then that the brother-in-law would purchase the property and the plaintiff would then effect improvements until such time that he qualified for a loan. And at the end of that, the property would be transferred back to the plaintiff from his brother-in-law, who is the defendant in this instance. So this whole issue speaks on repudiation. Now, just for some clarity, repudiation is when one person who is bound to a contract with another, whether by deed or any other form, indicates the intention to no longer be lawfully bound to the contract. Now, the innocent party has one of two choices. He may either accept repudiation and cancel the contract and claim for damages, or he may reject repudiation and demand performance. In this instance, why repudiation and prescription had come together was that the brother-in-law had indicated that at some time in 2008, due to the falling out of their relationship, he had evicted the plaintiff from the home. And he sought to argue that he, in so doing, repudiated the contract. In fact, the court found that no, that was not the case. The brother-in-law had failed to actually prove that he had repudiated the contract, because it had later transpired, some 2 years later, that he had sold the property unbeknownst to the plaintiff, and that when the plaintiff instituted action after finding out, obviously, of the selling of the house, that it was then that repudiation had been accepted and prescription had begun to run. So the court found that it is only when the innocent party had accepted the repudiation of the contract, then does prescription start to run. So it was a very interesting matter dealing with that, and not a very complicated one, to say the least. The second matter deals with, which is Fund Sale versus Road Accident Fund. It deals with impossibility and the application of the impossibility principle in issues of prescription. So in this instance, the claimant had been involved in an accident which had left him mentally unsound and had only instituted action some 7 years after the accident. It was established then that although the parts of the, sorry, I did see there's a question there. Let me just run through this case and then we'll deal with questions later. It was then established that the Road Accident Fund Act, particularly Section 23, is the part of the act which deals with prescription in these personal injury matters. And it was also established that that part of the act supersedes all other acts dealing with prescription. However, it was established in this case that there was no possible way in which the plaintiff could have complied with the provisions of that act, given his mental incapacity. And so they applied the legal principle of impossibility, particularly dealing with the fact that the law can never compel someone to comply with what is impossible. And it was decided then that this maxim, the benefit of this maxim, rather, is that it relieves a person from having to comply with provisions of a law when all possible circumstances will not permit them to comply. So it was a means in which they could ensure that there would be no grave absurdity when dealing with issues of impossibility. So the court ultimately found that the plaintiff's claim had in fact not prescribed, and they further held that when determining and interpreting the Road Accident Fund, which is sort of an underlying principle here, that when interpreting the Road Accident Fund Act dealing with prescription, it's important to read it together with the relevant provisions of the Constitution, being Section 233, as well as international law. And in this particular instance, it was the Convention of Rights of Persons with Disabilities, which in effect needed to ensure that there was equality before the law. So ultimately, just to restate the point, where it is impossible for someone to comply with a provision of the law, then that law cannot reasonably apply to that person. And that is why the court, the Constitutional Court in this instance, found that prescription did not apply. And in fact, although the claimant instituted his action some 7 years after the debt arose, he was permitted to institute his claim. Thanks, that's all from me. I will take questions at the end. So far, I would like to thank you for your time and move on to Tristan.
Indeed. Good morning, everyone. Before I start the slide, just two quick housekeeping things. Guys, you do have the chat and the Q&A function. Please feel free to use them. The panelists are going to be watching the chat and engaging in those discussions. So if you want to have the discussion, put it in the chat. If you want a question answered kind of towards the end a little bit more formally, please put it in the Q&A and we'll have a look at that at the end. Right. Legal expenses insurance, also known as LegalWise versus Malamu. I have the privilege of speaking about a judgment that I was actually involved in the running of the matter. And the facts of this one were interesting. So LegalWise, as some of you may know, is a legal costs insurer. What they do is you take out a policy with them, and if you have an issue which requires the appointment of legal representative in certain instances, they'll cover the costs. Mr. Malamu had such a policy, and he was dismissed from his job. He believed irregularly or unfairly. And he approached LegalWise, and LegalWise referred him to a bunch of panel attorneys that they have. So basically, they have a whole bunch of attorneys similar to Discovery with their kind of in-scheme doctors, that kind of thing where, you know, LegalWise says, listen, you can go to any of these attorneys, we'll cover all the costs, no questions asked. Otherwise, you can go to any attorney that you want, but then we have certain rates in that. It just so happens that the attorney Mr. Malamu ended up instructing was he let certain timelines slip, and his claim was ultimately dismissed because of them at the CCMA. And then he couldn't appeal at the Labour Court because the attorney didn't file it in time. So Mr. Malamu took great exception to the service that he had got from this attorney, and instituted action against both LegalWise and this attorney for a professional indemnity claim against the attorney, and was alleging that LegalWise was vicariously liable. Now, what the court ended up saying was that, as a general rule, an employer is not liable for the wrongdoing of an independent contractor, which this attorney was, unless the employer was personally at fault. So unless Mr. Malamu could prove that LegalWise had in some way contributed to the negligence of the attorney, they were not at fault, they were not vicariously liable. And I think that's the important part to remember here, especially for those of you who might have claims handling, might be empowered to handle claims handling on behalf of insurers, and that when appointing third-party agents, plumbers, electricians, etc., you can't dictate to the insured. If you do dictate to the insured that they have to use a certain agent, then there might be grounds to hold vicariously liable for the actions of that agent. However, in this case, where it was, here's a group you can choose, or you can choose whomever you want, and then we just have to have a discussion on price, the court held that there was no grounds to hold vicarious liability there. Jenny, you're up next.
You're on mute, Jenny. No, still can't hear you.
Jenny, can you hear us? Can you try speak?
Tristan,
All right, I think we're going to have to move to Ms. Crickler. You're next then. Jenny, we'll try come back to you. I'll chat to you, see if we can get that sorted.
yep, let's do that.
Okay. Morning, everyone. My name is Lisa Crichler, and I'm going to speak about the HAL on behalf of MML case, where the Supreme Court of Appeal rejected the res ipsa loquitur, or the matter speaks for itself doctrine, and shed some light on the onus resting on a plaintiff in medical negligence cases, more particularly where clinical records have gone missing. So the res ipsa loquitur, or the matter speaks for itself doctrine, is used to describe the proof of facts that are sufficient to support an inference that a defendant was negligent. So an example of this is where a surgical swab is left inside a person's abdomen during surgery. The fact that the swab was left inside the abdomen may be sufficient to support an inference that the doctor who left the swab inside the abdomen was negligent in doing so. So for a number of years, our courts have refused to apply the maxim in medical negligence cases following the widely accepted decision in Van Wyk versus Lewis in 1924. And in that case, the then appellate division cautioned that the maxim should rarely, if ever, be used in medical negligence cases where it has not been established what went wrong and where the views of experts are based on speculation, giving rise to various but equally feasible possibilities as to what could have caused the injury. In this HAL case, the plaintiff had sued the Free State Department of Health for damages, alleging that the hospital staff's negligence during labor had caused her child to suffer from cerebral palsy. And the plaintiff sought to apply the maxim, alleging that the mere presence of the child's brain injury was sufficient to support an inference that the hospital staff had been negligent during her labor. The records detailing the child's birth had gone missing, and both parties' experts had formulated their views and prepared their reports based on interviews with the plaintiff, who'd been found to be an unreliable witness. The expert views were therefore based on speculation and gave rise to various but equally feasible possibilities as to what could have caused the injury. Applying the reasoning in the earlier Van Wyk case, the SCA found that the maxim was not appropriate, as there was no evidence as to what caused the child's injury or when it had occurred. This case is also important because of what it tells us about the onus of proof in medical negligence cases. In this case, the SCA noted that if at the conclusion of a case, the evidence is evenly balanced, a plaintiff's claim cannot succeed because she would not have discharged the onus resting upon her, namely that on a balance of probabilities, the defendant had been negligent. And in this case, the department's negligence turned on whether the child had suffered the injury before, during, or after birth, and the defendant would have been negligent if the injury had occurred during birth by failing to adequately monitor the plaintiff and her fetus during labor or perform a cesarean section once fetal distress had been noted. And the court found that while the injury during birth could not be excluded, neither could an injury before or after birth. And also an injury during birth was not proven to be more probable than one before or after birth. So an injury during birth was not the most plausible inference to be drawn from the proven facts. And the SCA found that it would be purely speculative to conclude that the child's injury had been suffered during birth. Therefore, the plaintiff had failed to discharge the onus resting upon her and establish negligence on the part of the hospital staff on a balance of probabilities. Finally, the SCA noted that even if one assumed that negligence had been established on some basis, the plaintiff still would have had difficulty establishing causation, as there was no evidence that regular monitoring coupled with the prompt C-section would have resulted in the delivery of the child before the injury was suffered. The court dismissed the plaintiff's appeal altogether. I also just very briefly want to touch on the issue of missing clinical records. So anyone who's ever been involved in a medical negligence case, and in particular one relating to a birth injury, will know that clinical records are crucial to establishing negligence or denying it. It's incredibly difficult for experts to form an accurate understanding of what happened and when without clinical records. And in this HAL case, the plaintiff had alleged that the hospital concealed records to escape liability. And the court said that while it's not inconceivable that a doctor might be motivated to remove records to conceal their own negligence, a plaintiff may similarly be motivated to remove hospital records to conceal weaknesses in their claim. And in this case, the court held that the absence of the hospital records was a neutral factor and that negligence of the hospital staff could not be inferred from their absence. Thanks very much, everyone. I think I'm either handing over to Tristan, or if Jenny is ready, then I'll hand over to Jenny.
We're going to try Jenny first. Let's see.
Okay.
Jenny?
Hi, can you hear me?
Yes, we can. There we go. Go ahead.
Okay, great. That's excellent. Can you please just move my video on? Because I think my video has been stopped. But thank you everybody for joining us, and apologies for the technical difficulties. For my portion of the presentation, I'm going to be discussing the case of Kalagadi Manganese and others versus Industrial Development Corporation of SA. And this case basically dealt with the issue of mediation and Rule 41A, and whether or not mediation can be argued to have been in good faith or not. So the facts of this case dealt with the Industrial Development Corporation, or hereinafter I'll just refer to them as IDC, where they instituted an urgent application to place Kalagadi under business rescue. And Kalagadi, in response to this application, brought its own application to compel the IDC and other lenders to accept a restructuring sort of arrangement in the hopes of averting away from the need for the business rescue application. The IDC then suggested that the parties mediate to try and find a commercially and they elected to formalize the implemented Rule 41 was concluded, and they had 2 highly skilled mediators involved and appointed to the mediation process. However, some 2 months later, after the process had begun, IDC had decided to terminate the mediation process, which led to a new application being brought by Kalagadi and 2 other shareholders. And these parties basically argued that this termination was not in accordance to the mediation agreement, and that the termination of the mediation process was actually done in bad faith. Now, Kalagadi also went a step further and argued that since the mediation was in bad faith, it was therefore entitled to rely on certain documents and correspondence which had arose during the mediation process. Inevitably, the court had to deal with 2 issues, which was firstly, whether the mediation was in fact done in bad faith, and the second was the issue of confidentiality. Now, the court at the outset looked at the fundamental key concepts of what mediation is in general, and pointed out that mediation is really a voluntarily non-binding, non-prescriptive dispute resolution process. And it's one that has to be adopted through the agreed upon process by both parties or all parties involved. The mediator actually facilitates the process to enable the parties to find a proper solution. And it is not for a mediator to make any decision on merits, nor does he need to impose any settlement on the parties. And lastly, that the mediation process in itself is a confidential process. So the High Court Rule 41A is constructed on the premise of voluntary mediation between parties who basically remain in full control of the process and the outcome. Under this rule, a court is nevertheless expected to inquire into the conduct of the parties during the mediation when determining an appropriate order for costs. So essentially, issues of bad faith can be raised, but it's rather limited to comparing to the outcome of the case of, for example, offers and tenders, which may be done during the mediation process. And what the court would look at when understanding whether it's a bad faith mediation is looking at rather the conduct of the party, and does not necessarily take into account the state of mind of the parties, but rather their external acts. And this may mean failing to attend the mediation, failing to appoint a person who has sufficient authority to engage or conclude a successful mediation, or even a failure to prepare at all for the mediation session. Now, the rule really does encourage mediation through a mild-mannered approach, and it really just has a cost sanction at the end of litigation, or an option to abort the process if there is an abuse of it. In this particular case, the court had actually found that IDC did not terminate the mediation process in bad faith. And the reason behind this decision was the fact that there was consideration taken to the fact that it was IDC who had in fact initiated the mediation process. There were 2 highly skilled mediators who were appointed, and there was prima facie reflection of intention that IDC actually had intended to approach this mediation with the idea of settling between the parties. Unfortunately, during the mediation process, there was a point of intractable impasse between the parties, and therefore the mediation process didn't really get them past these issues. The court really looked at this as rather being of the challenges that result in mediation. With regards to delve too deeply into it, because in this case it said it would offend the confidential nature of mediation and the provisions of the mediation agreement if the court had to embark on an examination of the documents, or to allow these to be within the public domain, considering that there was no evidence of bad faith in this case, and therefore the documents should remain confidential. I'll now hand you over to my colleague, Tristan. Thank you very much.
Thank you, Jenny. Yes. So yeah, I'm going to be speaking about Bayam Trust versus Butcher Shop and Grill. So this is about rental remissions, specifically in, as you can see at the top there, COVID-19 business interruption claims. So as the court did in the judgment, I'm going to first just recap 3 general principles when it comes to rental remissions and BI claims. The first is that, and this is more just on tenant agreements in general, but a lessee is entitled to rental remission where there is a deprivation or a lack of beneficial property. So if as a lessee you by some superior force, so that's the other requirement, it needs to be because of what's called a vis maior, but because of some superior force or something outside of your control, you are unable to access the property that you've leased, then you're entitled to a remission on rental for the whole property if you've been deprived of the entire access or the portion thereof that you've been deprived of. The second important kind of general principle is that that the court confirmed here was that the lockdown regulations in response to COVID did constitute a vis maior causing material impossibility of performance. So because of the lockdown regulations, it wasn't possible for tenants to get to their properties and have beneficial occupation of it. And the third important thing to consider or to remember before we quickly discuss the facts here is that in a BI claim, presuming the appropriate cover, in this case they had cover for gross rentals, but in a BI claim where a lessor has not been paid rent because of a bona fide right of the lessee to rental remissions, then that lessor is entitled to reclaim that rent from their BI cover. So if I lease a property and the tenant is entitled not to pay me rent because of deprivation of beneficial occupation, then I am entitled to claim that rent from my BI claim. So that's the three general principles. This matter was slightly more complex because what happened here was that the landlord or the lessor had leased the property to a lessee or a tenant who had in turn subleased the property to a third party. So that was the first complication. The second complication was that the lease agreement here actually defined what beneficial occupation was. And it defined beneficial occupation as the physical possession and control of the leased property. And I think this is an important thing to remember in all of these kind of claims where you have specifically where you have contracts governing the agreements between people, is that you look both to the law and to the contractual terms. So here is a general principle: a lessee is entitled to remission of rent where they're deprived of beneficial occupation because of a vis maior, but the lease agreement defined what beneficial occupation was. And so what happened here, and what the court ended up finding was that because the lessee wasn't actually in occupation of the property and hadn't been for some time before COVID became a thing, they did not have beneficial occupation of the property to start with, because the beneficial occupation was defined as the physical possession and control of the leased property. So because they'd sublet it, they didn't have beneficial occupation to start with. And so because they weren't deprived of the beneficial occupation, they weren't entitled to a remission on rental. And this then had the consequence of the actual issue behind of this entire matter, which was that the lessor, the owner of the property, wasn't entitled to claim the rental remission from their BI claim, under their BI claim, because the lessee itself wasn't entitled to that rental remission. And so because the landlord or the lessor was entitled to claim its rent from its lessee, it was not entitled to claim it from its insurance. And I think that's an important thing to remember in a lot of these insurance claims, is ultimately the first thing that needs to be answered is, was there a valid loss? Was the loss legally valid? If the loss was not, if they could have reclaimed and didn't, then that's a commercial decision, and their insurance will not they'll not be indemnified by their insurance. Paulette, you're up next.
Thank you, Tristan. I hope everyone can hear me. Good morning, everyone. I am going to discuss wrongfulness and liability in personal injury claims against, insurers. So first of all, I'm going to start speaking about the principles, and then we'll go into the facts of the cases, which are quite interesting. So in the first case that I'm going to discuss, the court dealt with a claim where a boom gate had actually caused injury to a customer. So this customer went to Pick n Pay, and there was an area where people usually walked to get to the parking lot. And unfortunately, she was struck by a boom gate at the property, and therefore she sued for the damages that she incurred after the incident. In this matter, the court sets out that the true criterion for determining negligence, is whether the particular circumstances, the conduct in the particular circumstances, the conduct that was complained of by the plaintiff fell short of the standard of a reasonable person. So for instance, that would be determined by looking at whether in these circumstances, did the defendant foresee that such an injury could have occurred? And if they had, did they take the steps that a reasonable person would have taken to prevent such injury? And that's the test of a reasonable man. So in this instance, the question is now, if they had known that the boom gate could have hurt someone, did they take steps to mitigate the damage that could have happened? In this instance, the court found that Pick n Pay had actually been negligent in that they had only erected a sign quite late on after the erection of the boom gate, and also because there had already been an incident where someone had been struck by the boom gate. And despite this, they didn't slow down the functioning of the boom gate. They didn't change anything other than to simply put a sign that says beware boom gate. So in this instance, they failed to take care, they failed to act in accordance with the standard of a reasonable person. Something interesting about this, however, is that the court then apportioned the damages which Pick n Pay was liable to pay to the plaintiff, because the court found that she also failed to reasonably take care and also observe her surroundings. So she should have also looked and seen before crossing under a very apparent boom gate, which she had passed before and knew was of existence, to see that it wasn't coming down when she walked past. So she failed to pay proper attention, and she could have avoided injury as well, or the extent of injury, and therefore she was found to be contributory negligent. Another thing that the court looks at where a person has brought a personal liability claim is wrongfulness. So conduct where there is fault is actionable. And the criterion for wrongfulness, which will be looked at by the court, is dependent on the judicial determination of whether all of the elements of delict are proven or present. So if that is proven, then the court will then look at is it reasonable to impose liability on a defendant for the damages which have flowed from the specific conduct. In order to do this, the court will then look at public policy considerations and also constitutional considerations, which we will then look at a little bit later. So an example of where the court looked at this was in the matter of the Minister of Justice and Correctional Services versus Kitcha. In this matter, Kitcha lived in housing for correctional services employees. And the Minister of Correctional Services was obviously the custodian of such residential premises. One of the residents had dogs which were known to be aggressive and had already attacked another resident. And he had been issued with warnings from the minister or the person who was in charge. And despite this, the dogs then attached Mr. Kitcha, who brought a claim against the minister himself for failing to ensure that the neighbor did not ensure that his dogs didn't attack another person. In this instance, the minister had actually acknowledged that they had a duty to make sure that the neighbor didn't allow his dogs to attack people. And they, in their papers in this matter, they actually admitted that what they should have done was told him to get rid of the dogs. By so doing, they admitted that there was a duty to do so, and they had failed in such duty. So therefore, the minister himself there was found to have been acted wrongfully, where he knew he had a duty to prevent injury and had not done so. The last thing I'm going to talk about is indemnity clauses. Now, many of us, and I know I just came back from a game reserve, we signed many indemnity clauses where when we're about to go on a game drive, when we're about to do something fun, we sign a form where the service provider tells us that they are not liable for any damages we sustain. Now, where we've signed an indemnity clause, what happens when we do get injured and now someone does try to bring a claim against a service provider? The court has said that the question to determine whether indemnity clauses need to be should be upheld is whether they offend public policy or whether they're in conflict with the CPA. And the test for that is if the language of the indemnity which exempts the owner from liability, is set out in express and unambiguous terms. So if it's easy to understand, then effect will be given to that meaning. And the reason for that is it's a contractual principle of pacta sunt servanda, because self-autonomy and the ability to regulate one's own affairs it's a central part of contract law. And so if you are a customer who attends, someone who gives you a service, even if it's to your detriment, your ability to regulate your own affairs and to sign away or waive your rights to, indemnity, it's an important and it's also a vital part of dignity, which is a constitutional consideration. Now, the court has also said that if the language used in the indemnity is ambiguous, then the language must be construed against the owner, because clearly then, it can't fully be said that the person who signed the indemnity understood. Now, in consideration of this, the courts will look at fairness. Is the clause itself reasonable in the circumstances? And should it be enforced? That's also another consideration. So was there a good reason for the customer not to have complied? Now, usually indemnities are signed voluntarily, like I said. And so it's, fairness, the question of fairness is usually found to be in the affirmative. But the courts usually have to determine whether or not the claim should be upheld, looking at the circumstances of each case. The example I'm going to use here is the matter of Carol Jane Cooper versus Shamwari Hospitality. So Ms. Cooper went to a game reserve with her family.
Well, you'll have to be finishing off. You're a little bit over time, so we'll have to finish off shortly.
Sure. And very simply put, because she had passed the pool so many times, she was found to have been reasonably expected as an adult to know that there was a pool. Nothing was unusual about the pool. It wasn't dark, it wasn't not lit up, and therefore, the indemnity clause was upheld even though she was injured. Sorry, I'm going to hand over to Jenny, I think, who's next.
Thank you, Paulette. Can you hear me?
Yes, we can hear you.
Thank you. So for my portion, I'm just going to be discussing the case of the residents of Industry House and two others versus the Minister of Police. And literally, there is a portion of this case that I'm going to be dealing with, which was really interesting, and that is when a litigant can claim constitutional damages. Briefly, the facts of this case was between 2017 and 2018, the applicants in the matter, who were residents of various buildings in the inner city of Johannesburg, they were subjected to a series of raids and searches of their homes and possessions by South African police officials. And sometimes these police officials would also be accompanied by immigration officials from the Department of Home Affairs. And these searches all were conducted outside the ambit of Section 13.7 of the SAPS Act. So the applicants basically were instructed to go outside of their homes, and they were searched, and their fingerprints were taken, and they were basically their privacy was infringed. So all of these applicants launched an application in the High Court for an order declaring that Section 13.7 was unconstitutional in entirety, because it allowed for warrantless searches of a person, their home, and their property, as well as seizure of their possessions. They argued that this infringement to privacy, and the High Court disagreed with the applicant, saying that Section 13.7 wasn't unconstitutional, and that it really was an important legislative mechanism that allowed the police to declare that a portion of this section, which was Section 13.7c, where it allowed warrantless searches of a person's home or person's or inside of a person's home, was constitutionally invalid. And the declaration of invalidity was prospective and suspended for a period of 24 months. The High Court then ordered an interim reading in of the section, which had the effect of excluding private persons inside their private home, unless the warrantless search complied with Section 22 of the Criminal Procedure Act. The High Court then held that the interim relief was sufficient to protect the applicants from any further unconstitutional searches, and therefore the interdict that they were claiming was not granted. They had also claimed for constitutional damages at the High Court, which was dismissed on the basis that there was insufficient evidence to grant a blanket order for these damages. The applicants then took the matter off to the Constitutional Court for confirmation of the declaration of the invalidity and for leave to appeal. So the applicants made 3 submissions, essentially dealing with the constitutionality of Section 13(7). Its entirety, stating that the High Court had erred in granting the damages of 1,000 rand each. They're a breach of right and dignity. And they argued in this case, interestingly, that the award of constitutional damages was an appropriate surrogate for non-pecuniary loss caused by the negation of constitutional values embodied in breach of rights. The respondents opposed the application and they agreed with the High Court's findings. Now,
Jenny, unfortunately, we seem to be losing you. Yeah, I think we've lost Jenny. All right, Annika, we're going to have to move to you then.
Okay,
Yeah.
cool. Okay, perfect. Good morning, everyone. Thank you once again for joining us. I will be discussing unconditional performance guarantees this morning. And the case that I'll be dealing with is a matter of Sunroll versus Fountain Silver Engineering. I'm just going to refer to them as FCE throughout this discussion. So Sunroll and FCE concluded a contract for certain improvements to be effected to a section of the R23 freeway near Standerton. That's in Mpumalanga. The contract required FCE to obtain security to the value of 10% of the contract sum for the proper performance of its obligations to Sunroll. Lombard Insurance issued a performance guarantee on behalf of FCE in favor of Sunroll for the due fulfillment by FCE of its obligations under the contract, which would be effective until the works were completed. Lombard required FCE to sign an equivalent counter guarantee. Lombard would then be entitled to claim from FCE any amount paid to Sunroll under the performance guarantee. FCE did not fulfill its obligations under the contract and the works were not completed. FCE gave Sunroll a notice of termination on the grounds that it had become impossible for FCE to perform its obligations under the contract due to community unrest. Sunroll and FCE were then engaged in discussions concerning the resumption of works by FCE, but these discussions were unsuccessful and FCE elected to terminate the contract. Sunroll, however, alleged that it had actually given FCE notice to terminate the contract and that the claim would be made under the performance guarantee. FCE applied to the Gauteng Division of the High Court in Pretoria for an order restraining Sunroll from making a claim on the performance guarantee. FCE proposed an arbitral process and argued that the dispute resolution procedures agreed upon by the parties in terms of the contract, which were mediation and litigation, would delay the finalization of the dispute, and Sunroll rejected this proposal. The High Court ordered that an arbitral process be instituted within 21 days from the date of the court order, and pending the outcome, Sunroll would be interdicted and restrained from making a claim under the performance guarantee issued by Lombard. Sunroll appealed the order made by the High Court. The Supreme Court of Appeal firstly said that the High Court had no power to compel the parties to submit to arbitration to resolve their disputes. The contract provided that FCE and Sunroll had the right to refer disputes arising from it to mediation by a mediator selected by agreement between the parties. And where the parties did not agree, a mediator would be nominated by, and if the dispute was still not resolved, it had to be determined by court proceedings. The ACA said the effect of the High Court's order referring the dispute to arbitration was to amend the contract. The next point for the ACA to consider was whether Sunroll could be interdicted from making a demand under the performance guarantee. The ACA emphasized that performance guarantees in terms of which the guarantor undertakes to pay an amount if the contractor fails to perform the required work is unconditional. The beneficiary of the guarantee is not obliged to prove an entitlement under the principal contract before it can make a demand on the guarantee, and Sunroll was entitled to make a demand on the performance guarantee regardless of the dispute under the main contract. The ACA upheld the appeal and dismissed the application by FCE with costs. I'll now hand over to Retabile to deal with insurance policies and time bar clauses.
Thanks very much, Annika. Good morning, everyone. Thanks for joining us today. I will just very briefly go over these two cases that deal primarily with time bar clauses as well as grace periods that are provided within insurance agreements. The first case is the Qibi versus MyWay insurance matter, where essentially the plaintiff had submitted a motor vehicle claim, which was subsequently rejected by the insurer on the grounds that the plaintiff had supplied it with false information at claim stage. It was then common cause in this case that the insured had issued and served its summons while outside the time bar period and while outside the time bar provision. There was an implicit agreement, obviously, that proceedings challenging the rejection of a claim were to be initiated by summons, and that a letter of demand essentially was inadequate to interrupt the time bar or the running of the time bar period. The insured had admitted that the action was instituted outside the time bar period, but it challenged the validity of the clause on the grounds that its enforcement in this particular circumstance would be unfair and unreasonable. On this basis, of course, then the insured bears the onus of proving that the enforcement is unfair and unreasonable. And in doing so, the insured had alleged that he had essentially complied with the provisions of the contract by paying his premiums, and then at the time of the accident, he was up to date with his premiums. And then secondly, the dismissal of the special plea, which was the time bar that was raised by the insurer, would not necessarily mark the collapse of the defendant's case. The court rejected these submissions and stated that these aren't factors that it would take into consideration when it's determining issues of unfairness and unreasonableness. And the court further went on to explain that the contract was clear on the claims process to be followed. And, you know, the fact that the insured had lodged the claim punctually, which in turn was rejected with reasons by the insurer, every time that the insurer communicated its rejection and the reason therefore with the insured, that complied with the policyholder protection rules. And again, the various time bar and contractual prescription periods were clearly stated out and set out in the letter of rejection. And then again, on multiple occasions, the plaintiff was furnished with reasons for the rejection, and his rights were again fully explained in each of the correspondence from the insurer. And in these proceedings, the insured had no allegation, I'd say no allegation regarding illiteracy, and he was also legally represented at a relatively early stage of the proceedings. I believe he had acquired a legal representation during the claims process, even prior to issuing the summons. Ultimately, the court concluded that the parties who freely and voluntarily enter into a contract are essentially bound by the terms and conditions of that contract, and except, of course, where enforcement thereof would be unfair or unreasonable. And then the court reiterated that in this particular instance, the insured had failed to establish the issue of unfairness or unreasonableness. The second case is the case of Discovery Life versus Hogan, which is a very interesting case. It's involving a life policy where the insured had sort of informed its insurer that it wanted to cancel its policy because it wanted to obviously move to another policy which it regarded as a better policy. In response, the insurer advised the insured that, you know, it required a 30-day notice for all cancellations. Despite this advice, the insured proceeded to let its banker know that it must stop paying the premium for this particular policy. So at the beginning of the month, when the debit order was submitted, the insurer received, a notification back saying the payment has been stopped by the account holder. Now, in consequence of the non-payment, the insured was informed that the policy had been cancelled from the beginning of the month of default, being the 1st of September 2018. Now, there's a reason why I also mentioned these particular dates, because they become important for the events that happen afterwards. Now, as fate would have it, the insured died on the 22nd of September 2018 from gas poisoning at a tourist resort. The broker then advised the insured's executor to just quickly pay the outstanding premium, which was paid on the 27th of September 2018. They obviously did not mention to the insurer that the plaintiff had died. On receipt of the payment, the insurer informed the insured that in order for them to reinstate the policy, because if you remember, they had cancelled the policy and was sort of regarded the insured's non-payment as a repudiation, thus accepting the repudiation and cancelling the contract. So they informed the insured that in order for them to reinstate this policy, they require a fully completed and signed declaration of health from the insured. A claim was subsequently obviously submitted under the policy, and the claim was rejected because the premium for that particular month when the death occurred had not been paid. And the insured had also been notified in various ways, such as also they sent an SMS informing them that the policy had been cancelled with effect from the 1st of September. Now, what the executor was arguing was that the insurer was required to notify the insured of the unpaid premium firstly before cancelling the policy, and that they should have also afforded them a 30-day grace period to make the premium payment. And then they were alleging, of course, that since they paid the premium on the 27th of September, that fell within the 30-day grace period. Now, the insurer, on the other hand, argued that the grace provisions provided in the policy did not serve to extend the policy against the wishes of the insured after the policy had been cancelled, and it did not preclude the insurer from cancelling the policy immediately in the event of a repudiation, which essentially is what they were dealing with here. So the bank message that they'd received back to stop the premium payment was a clear indication that, the insured did not intend to comply with its contractual obligations. Now, in light of the insured's repudiation of the contract, the insurer, had obviously elected to cancel it and had also communicated its decision to the insured accordingly. The court agreed that the insured's conduct indicated that they had intentionally repudiated the policy, and then also agreed with the insurer's decision to ultimately accept the repudiation and to cancel the contract, and took a whole lot of things into consideration, from the manner in which this information was communicated to the insured, from the fact that the insured was a professional person who was assisted by a financial broker, and obviously should have full appreciation of what her policy requirements are, and that her actions in this instance were obviously intention of a person who wanted to move a policy to another insurer and essentially didn't want to pay a double premium for that month. Thanks.
Hi, we've on time and we've still got 2 talks to go. Do you want us to come back another time, or those who have got extra time, shall we just finish?
We only have one left, so.
Yeah, one.
Carry on. Thanks, everyone. I am mindful of the time, so I'll try and go through my section as quickly as possible. My name is Sadhna. I'll just be discussing the indemnity clauses and its relation to the Consumer Protection Act and some of the words whatsoever nature and howsoever arising. So the first case was briefly touched on by my colleague Paulette in the case of Cooper versus Shamwari. As Paulette mentioned, Ms. Cooper sued the game reserve because she had slipped and fell into the pool and fractured her right femur. The court found that the plaintiff had already had knowledge of the pool, having seen it during the day, and she'd given evidence that she had not forgotten about it. There were other people present with her that had avoided the pool and therefore found that, she did not keep a proper lookout when she was walking. The court also found, in the alternative, even if the lodge was at fault, it was entitled to rely on an indemnity clause contained in the registration document. The registration document contained a number of waiver and indemnity clauses, including a clause agreeing that the game reserve would not be liable or responsible for any bodily harm from whatsoever cause arising, including but not limited to injury. It also included a waiver and abandonment from all claims arising from whatsoever nature and howsoever arising. And acknowledging that the waiver and abandonment relates to any claim from whatsoever cause arising. The plaintiff claimed that the indemnity fell within the provisions of the Consumer Protection Act. She alleged that the terms were unfair, unreasonable, and/or unjust. And here the court found that the existence of the indemnity in the hotel and game reserve contracts were not unique or unusual. The plaintiff herself had said that she had signed these indemnities on a number of previous occasions. The clause did not exclude altogether her rights of access to court. It specifically recorded that there was no exclusion for liability for gross negligence or intentional wrongful conduct. And they also found that she was not in an unequal bargaining position when she signed the indemnity. So there was no evidence that she objected to the indemnity or that she was forced to sign it. In the circumstances, the court found that the indemnity was not unreasonable. She also claimed that the provisions of section 49.2 and 58.1 of the CPA was applicable. And in the circumstances, the court said that the swimming pool is not an unusual or unaccepted facility at the game reserve. It's a normal course subject to any risk. And the activity of walking on the deck to reach the restaurant was not an unusual risk. It was clearly visible, and 3 out of the 4 people that were walking with her did not walk into the pool. So the court then said that an ordinary alert consumer would reasonably be expected to notice the pool. And the plaintiff was not able to rely on any of the provisions on the CPA. And the court said that if causal negligence as alleged by the plaintiff had been proved, which it was not, the defendant was entitled to rely on the indemnity to avoid liability. The second case, which I'll quickly go through, was Schenker versus Fujitsu. Here, Schenker conducted business as a warehouse operator, distributor, clearing, and forwarding agent. And Fujitsu and Schenker concluded a written agreement that Schenker would from time to time, at Fujitsu's special instance and request for reward, make use of Schenker's mentioned services. All their advice, information, or services provided by Schenker was subject to the standard trading terms and conditions of the South African Association of Freight Forwarders. In June 2012, the SAA carried 3 consignments of computer and related accessories. Fujitsu, having imported these goods, had engaged Schenker's services for logistics, warehousing, cleaning, and forwarding thereof. There was an employee of Schenker, Mr. Al, and he was instructed to collect the goods and transport them to the warehouse. And what he did was he furnished the necessary custom release documents to the SAA cargo employees, and he then loaded the consignment onto an unmarked truck. So essentially, he never delivered the goods and essentially stole them. Fujitsu then sued Schenker for damages in relation to theft. Schenker conceded that at the time of the theft, Mr. Al was acting in the course and scope of his employment, and that unless liability was excluded in terms of the contract, they would be vicariously liable for the loss suffered. However, they argued that improper construction of the relevant clauses in the agreement excluded limited liability for the delictual claim for the theft of goods. The Supreme Court of Appeal, having regard to the facts, held that there was no ambiguity and the ordinary meaning of whatsoever nature and howsoever arising must be given effect to. The evidence was clear that the defendant and its employees dealt with and handled the goods, and no special arrangements had been made for the valuable goods. The court found that the ambit of the clauses was wide enough to include intentional acts by employees of the defendant, and the exclusion of liability under the relevant clauses included loss damage, expense arising from anything connected with the non-delivery, misdelivery, or any goods covered from the delictual claims. So the Supreme Court of Appeal essentially upheld Schenker's reliance on their disclaimer of liability provisions in its warehousing and distribution contract with Fujitsu. So these two cases show that there is a popular belief that the courts generally side with the insured, but these two cases show that our courts do hold contracting parties to their bargain and do enforce the disclaimer of liability clauses in the right situation. Thank you.
Okay, thanks, Adna. Okay, so I will be dealing with the last case today, Minister of Police versus underwriters at Lloyd's of London. And this is about security companies, vicarious liability, and joint wrongdoers. So Lloyd's of London covered a cash and transit company, SBV, for the theft or destruction of cash it was holding on behalf of major banks. Two serving police officers planned and executed a robbery by gaining entry to the premises of SBV, accessed a secure vault, and took off with approximately 100 million rand. During an investigation of the robbery, it came to light that an employee of SBV, who was employed as a security compliance officer, conspired with the two police officers and provided them with information to facilitate the execution of the robbery. SBV lodged a claim with Lloyd's to compensate it for any and all losses incurred as a result of the theft of the cash. Lloyd's paid SBV in terms of the insurance policy. Lloyd's then took cession of the bank's claims against SBV and third parties, including the minister, and cession of SBV's claims arising from the robbery. Lloyd's instituted a delictual claim against the Minister of Police for damages in excess of 100 million rand, and the cause of action was based on the allegation that the Minister of Police's employees acted within the course and scope of their employment as police officers and failed in their duties to prevent the robbery and not to participate in criminal activity. Lloyd's alleged that the Minister of Police was vicariously liable for the losses incurred as a result of the robbery. The minister denied that it was vicariously liable and pleaded that Lloyd's had not incurred liability to compensate SBV and therefore did not incur any losses. The minister's reason for saying that Lloyd's had not incurred liability to compensate SBV was because SBV was a co-perpetrator and accordingly it, and by extension Lloyd's, could not profit from its own wrongdoing by pursuing a claim against the other wrongdoer. The Supreme Court of Appeal quoted a section from the case of Minister of Safety and Security versus F and said, vicarious liability has a long but uncertain pedigree. In essence, it may be described as the liability that one person incurs for a delict that is committed by another by virtue of the relationship that exists between them. There are two features of vicarious liability in its traditional form that are trite, but they bear repetition. The first is that vicarious liability arises by reason of a relationship between the parties and no more. It calls for no duty to be owed by the person who is sought to be held liable, nor for fault on his part. The second feature is that it is secondary liability, and it arises only if there is a wrongdoer who is primarily liable for the particular act or omission. In essence, vicarious liability is a strict liability. For example, the intention to commit unlawful conduct on the part of the primary wrongdoer, let's say, for example, an employee is not attributable to the party secondarily liable in this example, it would be the employer. Lloyd's was entitled to institute a delictual action against the employer of those defendant third-party robbers and any member of the gang of robbers. The delict is committed against SPV and by extension Lloyd's, which was without fault and could not be both robbed and at the same time liable in delict for the actions of their robber employee as against the party from who they seek to recover. The claimant might have a liability to its clients in contract whose property was lost as a result of the robbery and which harm was suffered in consequence of the conduct of the claimant's employees and the third party's employees, but it is not vicariously liable to itself. The conduct of SBV's employee, who was the co-perpetrator, could not be attributable to SBV in order to enable the third-party defendant to resist the delictual claim, and the appeal by the Minister of Police was dismissed with costs. Thank you very much.
Thank you all for your patience. I don't know if there's still some here. I'm prepared to answer questions, or you can send us some written questions and we will revert.
Yeah, Mr. Coronis, I think so. There's a number of questions on slip and trips and disclaimer notices. I'm just going to say to everyone, next week's Tuesday is about slip and trips, and if it's not already, I think we'll definitely make sure there's a section there on disclaimer notices. So I think if we put all of those aside, so if you do have further questions, just pop them and I'll see them and can divert them. The only one at the moment is there's one from an anonymous attendee here who says, with the COVID BI claims, the client has infectious diseases cover. Can they claim the remission/rebate of rentals allowed as the tenant was not able to trade or had restricted trade? So Mr. Anonymous or Mrs. Anonymous attendee, the simple answer to that is it depends on the lease agreement. So what there needs to be is there needs to have been a valid reason or a valid entitlement on the behalf of the lessee to a remission and rental. If the lessor kind of its own accord decided to reduce its tenants' rentals to be nice or whatever the instances, then that's ex gratia, that's a commercial decision, and no, they would not be entitled to recover that from their BI cover. However, if the lease agreement, for example, had a clause about remission of rental, which entitled the lessee to a remission and rental, then yes, that could be claimed from the insurance cover. So I hope I've covered that one. I haven't seen any further questions come through. I'm just scrolling quickly. Also, massive appreciation to all of you saying thank you. It has been a pleasure on behalf of all of us. I see Daphne Thompson has her hand raised.